Good morning, everyone. We are Group 7 and we are going to report about voidable contracts. Next slide, please. So here, Article 1390. The following contracts are voidable or annulable, even though there may have been no damage to the contracting parties. First, those where one of the parties is incapable of giving consent to a contract. Two, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. So these contracts are binding unless they are annulled by a proper action in court. They are susceptible or ratification by Janine Gumacol. So voidable contracts are governed by Article 1390 to 1402. Consent is one of the three essential elements of contracts. If the consent of one of the parties is defective or vitiated, the contract is voidable. Defect or violation of consent is caused by either internal or external factors. So consent as an element of contract must be intelligent and free. If either attribute is impeded or impaired, then consent is said to be vitiated and the contract voidable if any of these conditions are met. So the injury party has the right to ask the court to annul the contract. So next slide, please. So what is the meaning of voidable contracts? Voidable or annulable contracts are those which possess all the essential requisites of a valid contract, but one of the parties is legally incapable of giving consent, or consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. So it refers to a legally binding agreement that is essentially valid and enforceable, but due to a certain circumstances or the actions of one of both parties involved, it can be declared void or notified at option of one of the parties. In other words, a voidable contract is one that is capable of being cancelled or avoided by one party, typically due to some legal defect, mistake, misrepresentation, undue influence, or incapacity. When a contract is voidable, the party with the option to void the contract can choose to either affirm or disaffirm it. If the party affirms the contract, it remains valid and enforceable. However, if the party decide to disaffirm it, they can treat the contract as if it never existed, releasing themselves from any obligation under the agreement. It is important to note that a party with the option to void the contract typically needs to exercise that option within a specified time frame or before certain conditions are met. If the voidable contract is not timely voided, it may become binding and enforceable, and the party may lose the opportunity to cancel the agreement. Voidable contracts offer a degree of protection to parties who may have been coerced, deceived, or lack the legal capacity to enter into a contract. They provide a mechanism for those parties to escape from agreements and they will have not entered into under fair and proper circumstances. Next slide, please. So there are only two types of voidable contracts. So first is binding force of voidable contracts. So they are existent, valid, and obligatory unless annulled or set aside by a proper action in court. Example, an action instituted for the purpose. Once ratified, they become absolutely valid and can no longer be annulled. The existence of damage is not essential for their annulment as in the case of rescissible contracts. So the existence of damage is not essential for their annulment as in the case of rescissible contracts. The binding force of avoidable contract is conditional and dependent on the action taken by the party. So, if the option to void to contract until the party exercise the right to void the contract, it remains legally binding and enforceable. This means that both parties are obligated to fulfill their respective duties and obligation as outlined in the contract. However, once the party with the option to void decide to exercise that right and properly communicates their intention to do so, the contract becomes voidable. This means that the contract is no longer binding on the party who chooses to void it. They are released from their obligation and are not required to perform under the contract. It is important to note that while the party with the option to void can choose to nullify the contract, the other party does not have the same right. In other words, if the contract is not voided by the party with the option, it remains valid against the other party. Only the party with the power to void the contract has the ability to release themselves from its obligation. Next slide, please. So, the meaning of annulment. Annulment is a remedy as well as a sanction provided by law for reason of public interest for the declaration of the inefficacy of a contract based on the defect or vice in the consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. So, annulment refers to legal process through which a marriage or other contractual agreement is declared null and void as if it never existed. It is a legal mechanism to invalidate a marriage or contract, usually due to specific grounds or circumstances that render it legally invalid or voidable. In the context of marriage, an annulment is a legal declaration that deems a marriage null or void from its inception. Unlike a divorce, which dissolves a valid marriage, an annulment treats the marriage as if it never took place. The grounds for annulment vary by jurisdiction but often include factors such as fraud, bigamy, lack of consent, underage marriage, mental incapacity, or prohibited relationship. When a marriage is annulled, it is generally retroactive, meaning that the legal status of the marriage is considered void. From the beginning, as a result, both parties are legally regarded as if they were never married, and the legal rights and obligations associated with marriage, such as property division, and inheritance are typically treated differently than in other divorce. So similarly, annulment can also apply to other types of contracts, not just marriages, but contract is annulled, it is declared to be invalid and void from its exemption, as it never existed. So the grounds for annulment of contracts may vary depending on the jurisdiction and the specific legal requirements for each type of contract. Common grounds for contract annulment include fraud, misre- misrepresentation, duress, mistake, and illegality and incapacity. So next slide, please. So what is the difference between action for annulment and action for rescission? So there are following. First is the first base is arbitration of consent under Article 1390, while the second on lesion is to one of the parties or to a third person under Article 1381. So second is the first may brought only by a party to the contract under Article 1390 and 1397, while the second is also by a third person who or suffer damage by reason of the contract under Article 1381. Third is the first is a principal action under Article 1390, while the second is merely subsidiary under Article 183. Next slide, please. Four is the first presupposes that the contract is legally defective under Article 1390, while the second that the contract was validly entered into Article 1380. So the fifth is the first seeks to imposition of sanction by law on the guilty party for reason of public interest, while the second is a remedy allowed by law on ground of equity. Six is the purse allowed even if the supplantive has been indemnified, while the second is barred by such indemnification. So, the distinct difference between ang action for annulment and action for rescission, it's take note that it's important to note that the law has specific provision and requirements for both annulment of marriage and rescission of contract. Seeking legal the advice from a qualified lawyer is recommended when considering either action, as the specific circumstances and applicable law can vary on a case by case basis. So next slide and next reporter, please. Thank you.
So we proceed to ratification. What is ratification? Ratification or confirmation is defined as the act or means by virtue of which efficacy is given to a contract which suffers from a bias of curable nullity. Ratification is defined as the affirmation by a person of a prior act that did not bind him or her, but was done on his or her account. The act is then treated as if he or she originally authorized it. Government employees can ratify action of any unauthorized agent if the individual ratifying the action has the actual authority to enter into a contract and the government benefits from the action. So we proceed to requisite of ratification or confirmation. Number one, the contract should be tainted with a vice which is susceptible of being cured. Second, the confirmation should be effected by the person who is entitled to do so under the law. And third, it should be effected with knowledge of the reason which renders the contract voidable. And last, the reason which renders the contract voidable should have already disappeared. Next slide, please. Next slide po. So we proceed to rescission versus annulment. The rescission, the basis here is lesion. By annulment, the basis here is violated consent or incapacity to consent. And next, the defect here is external or extrinsic. By annulment, the defect here is intrinsic in the meaning of the mind. And the action is subsidiary. By annulment, the action is principal. Plaintiff may be a party or a third person, so by annulment, plaintiff must be a party to the contract, whether bound principally or subsidiarily. There must be damage to plaintiff. By annulment, damage to the plaintiff is immaterial. Next, if plaintiff is indemnified, rescission cannot appear. By annulment, indemnity here is no bar to the prosecution of the action and compatible with the perfect validity of the contract. By annulment, here a defect is presupposed. And last, to prevent rescission, ratification is not required. By annulment, to prevent annulment, ratification is required. So, in conclusion, is that annulment is an act or instant of annulling, while rescission is an act of removing, taking away, or taking back. Next slide, please, and next report.
Next slide po. Article 1391, the action for annulment shall be brought within 4 years. This period shall begin in cases of intimidation, violence, or undue influence from the time the defect of the consent case. In case of mistake or fraud, from the time of the discovery of the same. And when the action refers to contracts entered into by minors or other incapacitated persons, from the time the guardianship ceases. This article only applies to the parties in the contract. It does not apply to a third person when the law allows them to question the validity of a contract. Failure to pursue an action within the period prescribed by law will have the effect of extinguishing the action. With regards to fraudulent conveyances, with the registry of property, the prescriptive period is counted, not from the actual knowledge of the fraud, by the plaintiff, but from the registration of the public document with the said registry. The act of registration is a notice to the whole world. It is the operative acts that binds registered lands under the torrent system. Next slide po. The action for annulment of contract and the action for nullity of contract. Action for annulment of contract is one filed where consent is violated by lack of legal capacity of one of contracting parties, or by mistake, violence, intimidation, undue influence, or fraud. Those where one of parties is incapable of giving consent to a contract. Those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. Action for nullity of contract. An action for declaration of nullity of contract presupposes a void contract of one where all the requisites prescribed by law for contracts are present but the cause, object, or purpose is contrary to the law, morals, good customs, public order, or public policy, prohibited by law or declared by law to be void. Such contract, as a rule, produces no legal and binding effect if it is not set aside by direct legal action. Neither may it be ratified an action for declaration if nullity of contract is imprescriptible. Next slide po, next report po.
Good morning, everyone. In Article 1392, ratification extinguishes the action to annul a voidable contract. So, ratification meaning it means despite knowing na may defect yung contract, you still adopt or approve that contract. So, meaning yung intention mo is to ratify or to be bounded by that contract kahit alam mong pwedeng ipa-annul but you choose to be bind by that contract. So effects of ratification. First is the action to annul a voidable contract is extinguished. Hence, the contract becomes valid. So this explained that with further or subsequent or approval or consent with the injured person, it removes the defect in the contract, and that injured person is binding himself with the provisions in the contract. So the second effect is the contract is cleansed of its defects from the beginning. So when the injured person ratifies the contract, it is cleansed with all of its defects from the moment it was constituted. Hence, the contract is valid and the act to annul is already extinguished. Next reporter, please.
May audible na po? Audible na po ba? Excuse po. Article 1390. Ratification may be affected expressly or tactically. It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contacts avoidable and such having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. It is an act of occurring the defect of lack of excess of authority of the party who entered into the contract another through another without the latter's authorization. It covers viable contracts and especially refers to unenforceable contracts. The contracts is a viable. Next slide po. And this is the three kinds of ratification. The first is express ratification. The ratification is manifested in writing. Second one is implied ratification.
may take different form by silence of acquiescence, by action adoption of principle of the contract, may acceptance and retention of benefits po. The last one of the kinds of the requisites of ratification, there are four categories. First one is the contract is avoidable one. Second one is the confirmation is made by the injured contracting party. Third one is confirming part. The confirming party has full knowledge of the price of effect of the contract. And the last one is the cause of violability have already ceased or disappeared at the time of ratification. Otherwise, if the cause of violability is present, subsisting intimidation, the act of its confirmation will also suffer from the very nice or defect it is attempting. That's all for the Article 1393. Next slide po. That's all po. Thank you for listening.